Welcome, everyone. This is the second class of the complete course for the February 2024 Ibis Prep Florida Bar Crash Course. And we are super excited because today I get to teach about how to write incredible Florida contracts essays. And the last class, I know I kind of recited it for everyone just to prove that it's memorizable, if that's a word, and something that we can all strive to do. But today I'm going to share my screen and show you all exactly what to write, and maybe we'll have some time to go over the questionnaire and give you some insight into writing your essays. On Saturday from 11 to 1, we're going to do an essay workshop where we'll go over multiple essays and I'll show you how to write them. We'll look at the model answers and we'll just learn the process for writing really strong essays. So I'm going to go ahead and share my screen. And there's a few different things I'm going to work off of today, but I'll start with this document that I created with a student today, and she should be here in a minute, but she created it, I oversaw it, and if there's anything we should add to it, we could add it today as a class. So right now, everyone see my screen? Okay. So the first issue is whether there is a contract, and I can share this with everyone, and it's going to be added to the Google Classroom, and it's part of the drive and all those things. But if you could see it, you could write along with it and know that you're going to have access to it. So don't fret. The first issue is whether there's a contract. A contract is defined as an agreement between two or more parties in which there are valid remedies of law. Contracts can be unilateral, accepted by performance, or which require contract formation. Different types of contracts include installment contracts, requirement contracts, output contracts, and divisible contracts, contracts that can be divided. So long as there's valid formation and absent any defenses, there's likely an enforceable contract. Now, what I meant by that is everyone knows we do body of law, we do formation, we do defenses, and we do damages. We know those four pieces, but we can get more points. And how can we get more points? By just identifying things at the beginning, like what type of contract is it? And as she put here in 3, who are the parties? And it's important to note who the parties are. So some things that you can note about the first issue is whether there's a contract. I told her to assume that there is a contract absent any defenses, and so long as there's valid formation, meaning it looks like a contract, it smells like a contract, it's probably going to be a contract, because a contract is an agreement between two or more parties, and there are two or more parties here, there is an agreement, so there's probably a contract. We're just going to analyze it a little bit more. And it's probably a type of contract, and we can get points for discussing what type of contract is it. Unilateral, like a poster for the dog. If you find the dog, you get paid. That's a unilateral contract. Versus a bilateral contract, which requires contract formation, offer, acceptance, consideration. Maybe you could write C below or something like that, but you'll get into a bilateral contract. Installment contracts, you're looking for a contract that payment occurs in batches. Payment occurs in installments. And remember, with an installment contract, one breach is usually not a material breach. It's a minor breach, and there'll be an opportunity to cure by the other party. We could have output contracts, something that I wish she had put here, and it's hard for me to type right now, but would be requirements contracts, right? They're kind of the opposite of each other, but under the same umbrella. An output contract or requirements contract, meaning an output is we'll produce or we'll buy whatever you output, whatever you produce, and a requirements contract will produce whatever you require. Look out for that. They'll put verbiage. Something to take note of is the writers of these essays write the essays to enable students to get points. So if they start mentioning, Tommy says he'll buy all of the corn that he grows, that's an opportunity for you to determine what type of contract is it and get a point. Vocabulary words are opportunities to get points because other people that aren't lawyers wouldn't know what that means, and your job is to write a memo that clarifies what things mean and to describe the potential issues, rules, analysis, arguments, opposing arguments, and conclusions. So anyway, talk about that at the beginning, but don't spend too long on any one thing. I don't want people to go overboard on this. Just think at the beginning, okay, is there a contract? What type of contract is it? Let's move forward. Governing law. The next issue is whether the contract is governed by the UCC or by the common law. The UCC governs contracts for goods, and goods are all things movable. Point for that. The common law governs contracts for services or land or anything else besides goods. We can talk about the predominant purpose test. If a contract includes goods and services, the court will look to which predominates the contract and apply the corresponding body of law. So what do I mean by that? I mean that if there is a contract that has services and goods, so let's say a tutoring contract with books. Tutoring is a service, books are goods. Well, the tutoring predominates the contract, we're going to apply the common law. Unless you are charged separately for the services and the goods, then you could potentially argue for divisibility of contract and apply UCC to the goods and common law to the service contract. Divisibility of contract is an interesting word because it kind of has two implications. There it implies dividing a contract in terms of the subject matter. It could also imply dividing a contract in terms of the execution. It just means more like splitting up a contract. Dividing in terms of the execution means build 3 barns. Well, you build one and then you say you're not going to build anymore. We'll divide it into contracts to build 1 barn and 2 barns, right? Or build 3 bathrooms and you only build 2. Well, we can divide it in the execution and someone will build the other one. In the formation is it UCC or common law that's going to apply? We'll divide it and say it's 2 different contracts from the beginning. UCC applies to the goods, common law applies to the services. Does anyone have any questions about that? About contract formation and whether there's a contract or not? Just give me 1 second. Sorry about that. Okay. Are people bored yet? Are we having fun? This is review. If this is super review, that's good. Because eventually you want to get like me. I'm at a networking meeting this morning and they had a picture of us. We went to breakfast and I was in that picture amongst 30 people and they're big shot attorneys, big shot financial planners, financial accountants, marketing people, all sorts of big shots in their suits and ties, and me just in my little Ibis prep shirt. And the president showed that picture to someone and that person pointed me out and said, I know that person. If it wasn't for him, I would have never been a member of the Florida Bar. And I was like, everyone started clapping for me and they're like, yeah, we have a rock star amongst us. I got all, red in the cheeks, all shy. And it made me realize that like, this is pretty cool. Knowing the material really well can turn you into a rock star, let's say. And that's just something to say that if you are hearing this stuff so repetitively, maybe that's a good sign. Maybe that's a good sign you could come work for us and be a future rock star. Maybe it's a sign you're going to pass the bar exam. But whatever it is, the goal is to make this easy. So you remember this information so much that it's easy for you to recite it. That's definitely the goal. So far, the first issue is whether there's a contract. The contract is agreeable, is a agreement between 2 or more parties in which there are valid remedies at law. There's different types of contract: unilateral, which can be accepted by performance, or bilateral, which requires contract formation. Different types of contracts are installment contracts, requirements contracts, output contracts, or divisible contracts. Here, it seems that there's a bilateral requirements contract absent any valid defenses, and so long as there's valid formation.
And Andrew, I have a quick question, if it's okay to.
Yeah, go.
So just to go back to the predominant purpose test, just to be clear, if there's a contract that involves both goods and services, the test is going to require that we determine which aspect is dominant and then apply that law, that dominant law, to the whole contract, or are we saying that the predominant purpose test is like basically making the contract divisible, where like we apply common law to the services and we apply UCC to the goods?
So, see, I could be a law school professor. It depends. Next question. No, I'm just kidding. But that is kind of the answer. When I say it depends, I mean that the majority answer is the rule of law here is we're going to apply the predominant purpose test, and common law or UCC will apply to the entire contract. We'll just say they're all wrapped together, kind of like if you remember from secure transactions like accession or commingling, like it's all bundled together. If there is a predominant purpose test, whatever predominates, that body of law will apply to the entirety of the contract. What I was saying is there's an argument for divisibility of contract in the rare scenario, that's why it says it depends, in the rare scenario where it's clear in the contract that it's very possible to divide it between the goods and the services. And the way that makes it very clear is if it's delineated price terms on the invoice. Like a lot of people in this class bought materials and services, but most of them just got an invoice for the class. If you were to have gotten an invoice that said 10 hours of tutoring for $100,000, I was like the wishful thinking, and then 5, pieces of lectures and books, whatever, for $100,000, you could split it up, right? Because it says the prices and it says the good or service that's attached to it. But if everything's bundled together and there's no way to really differentiate what is priced by what, then you're going to utilize the predominant purpose test. And everything I said just flew over your head. The takeaway there is that you're usually going to apply the predominant purpose test, which means whatever predominates the contract, that body of law will apply to the entire contract.
Okay, got it. Thank you.
All right, no questions. Ask me questions away, because like I need some water breaks. I got something like I don't know. Like I'm good, but I could use some water every now and then. I think I've just been talking too much today, which is like stirring my leg. All right, the part 3. It is important to note. This is like my favorite thing to say. By the way, is anyone alive there? Because like I don't really love looking at faces I can't see.
I'm alive. We're alive. Yeah.
All right, nice, Gabby, the birthday girl. What's up? So far so good, right, Gabby?
Yep.
All right, perfect.
So far so good.
Okay, when I say is anyone alive, it's because on this particular device, I'm only seeing one person at a time, and it's just easier for me to teach to someone who's there. But it's all good, whatever. Okay, so is it important to note whether parties are merchants because there are special rules that apply to merchants, including blank. That phrase is important to note. To me, it's like people who like Parmesan cheese on their pasta, right? I just love it because it's so nice to be like, I'm gonna try and get some points here. I'm gonna deviate a little bit from the path of my essay, but I'm not going to deviate too far. I'm sorry, one of my students is saying that they're having a problem with their Zoom, but maybe they can figure it out. So they're not going to deviate too far. What I try to relate that to, if everyone knows the rule about responding superior in torts, where you are liable for your employee if it's just a detour, but you're not liable for a frolic. Does everyone remember that? I know I'm taking a little mental detour here, but does everyone remember that? Like in torts, responding superior, the employer is vicariously liable for detours, but not frolics. A detour is like going to get coffee. A frolic is like going to do drugs with your ex-girlfriend or something, right? Same thing here with me doing this lecture and y'all when you write your essays. It's okay to take detours. Do not take frolics, right? Is it important to note is a great way to take a little detour. Because, hey, I'm just going to say it's important to note this, and then I'm going to get back to what I'm doing. I'm not going to go all the way down that rabbit hole if it's not going to get me too many points. But one place where I love using is important to note is merchants. Because at the beginning of your essay, you can get points for identifying the parties. And there's only one specific party that matters. I don't want to say I don't know it's one, but there's one specific party that matters in contract law, and that party is that's when we have merchants as a party, right? merchants are people who partake in the sale of goods that are of the type at hand, right? Merchants are people who regularly do business and transact in the subject matter of the contract. How do we know that there's merchants? Because they literally tee it up like it's a 6-year-old playing t-ball, and they're putting a little ball on the tee for you to hit. They'll be like, Tommy, a professional interior designer, and Johnny, a retail seller of concrete, right? They tell you that they're merchants because they explain that they are seasoned and professionals in their field. So look out for that on the test. Highlight that, underline it. When they tell you who Johnny is, or they tell you who Tommy is, ask yourself, are they a merchant? And why is that important? Because it's important to note that there are special rules that apply to merchants, right? There's the firm offer rule, no consideration necessary for modification, the battle of the forms provision, knockout rule, written confirmatory memo rule, perfect tender rule, and 30 days to respond to request for further assurances rule. These are some of the ones that the student and I, who can't get into the Zoom right now, fleshed out today.
Andrew?
Yeah.
I just have a question. I know that merchants are like, have like a certain word, like if they say someone specializes in something, but what about like companies? Would you assume that they're merchants?
No, a merchant must be an individual. A company, if it's like Nike and Andrew the tutor, have a contract together, they're sponsoring me. Nike would not be a merchant. A merchant is an individual. But most of the scenarios will have a representative of the company who could very well be a merchant. But if it's just dealing with the company itself, I'm under the impression that that's not a merchant. If anyone, disagrees with me, I'm open for debate on that, but I don't think that a corporation would qualify as a merchant, because a merchant is someone, a person who deals regularly in the course of business with the subject matter of the contract. Very good question, though.
Hey, this might be arbitrary, but say the corporation or representative held themselves out to be as a merchant.
Yeah, and again, the beauty of essays is you can always argue both sides. And if you don't do that on subjective topics on the exam, you're doing yourself a major disfavor. I've taken the MEE, which is part of the UBE, and I've taken Florida, I've taken California. Of all of them, Florida not only gives you the most room for elaboration, but requires elaboration. It requires argument, counter argument. They don't just want you to say, this is the black and white answer to the question. So here I would argue, the corporation is holding themselves out as an entity that regularly does business in this, field. Therefore, Johnny would argue that they're merchants and should be held to the confirmatory memo rule, or the whatever rule it may be. Again, that's the beauty of essays. The corporation will argue that they're not merchants because they're a corporation and merchants are, you can go back and forth. But again, it really comes back to that detour, not frolic, because the essay is not going to harp on something that I'm not even like harping on. And that's really what I think separates me from other companies, other tutors. Companies, tutors, are they merchants or not? Who knows? But that's what separates me from the other merchants or not merchants, is that I'm focused on what they focus on. I know the test. I've taken the test. My students have taken the test. My tutors have taken the test. We've discussed what's heavily tested. And it's not a minimum competency test. It's a maximum competency test of fundamental issues on the test, and then a good understanding of everything else. But the things that are fundamentally tested, you want to focus on the contract essays. So to, kind of not detour too much, one thing that's heavily tested is the battle of the forms provision. So, Grace, do you know what the battle of the forms provision is?
The battle of the forms provision. Yeah, I think so.
So
I hate it when you put me on the spot.
no, I had to text someone real quick. Okay, valid forms provision. Let's just say they're merchants under the UCC, and there is an offer and an acceptance, but the acceptance includes an additional term. Under the UCC, valid forms provision, that additional term will be part of the contract unless the offerer expressly rejects within a reasonable time, 10 days to be assumed. That's the concept right there, is it's not a counteroffer. So Grace, we're under the UCC, so I'm offering to sell you pens. By the way, I got a nice amount of these pens. If anyone wants a Ibis Prep pen, I don't know if you can see this, but if anyone wants this Ibis Prep pen, it's for sale right now. So Grace, I say I'll sell you these pens with Ibis Prep font on it, with the Ibis Prep logo on it for $100 a pen. I don't want to get into statute of frauds here, so don't even get into that. But we have an agreement, right? And you say it's all in writing, and you say yes, okay, I agree, and the font will be Helvetica, right? Now let's just say font in the industry is not a material term. Again, argument both sides. It's contract. That's it. The assumption there is your acceptance that you agree to buy the pens. You've accepted, and the additional term that the font will be Helvetica. Does everyone know what that font is, Helvetica, and the significance of Helvetica? It's a font that is widely used in business, and the idea is that advertisers have learned that it's the font that like results in you buying stuff. I studied all this in college. I see you do learn some things in college. Okay, so anyway, Helvetica, right? You say that you accept it, but the font is gonna be Helvetica. That is a minor alteration. That is an additional term that does not materially alter the contract, right? Let's just assume that. So therefore, we have a contract, and the contract includes Helvetica font. Why? Because under the UCC, between merchants, the Battle of Forms provision states that an acceptance that includes a material term, additionally, an additional material term that is not material. I'm sorry, let me restate that. Under the UCC Battle of Forms provision, an acceptance that includes an additional term that is not material constitutes an acceptance, and the additional term will be part of the contract. So how do we write right here? Additional terms that do not materially alter the contract will be included in the contract and is considered an acceptance, not a counter offer. So when Grace said, I accept the offer to buy 10 pens, we're going to use Helvetica. Under the UCC, assuming we're both merchants, assuming that's not a material term, we will have a contract with Helvetica. Now, this is an essay. This is not multiple choice. You will argue that the font, A will say, Jimmy will say that in the industry, choice of font is a material term, and B will say in the industry, choice of font is not a material term. What if Jimmy is successful and it is a material term? That's when we apply the knockout rule. We still have an acceptance, but that additional term is knocked out, and now UCC gap fillers will apply. The UCC will, look to the industry and apply something that is fair and equitable. So that's what the Battle of the Forms provision means. There's an essay, and I might have just assigned it to y'all, I don't remember, but they talk about arbitration clauses, they talk about waiver of jury duty. Arbitration clauses are right on the border of whether that's a material term or not. You'll argue both sides. A waiver of damages or a waiver of liability is a material term. That's something that is going to be knocked out, right? Like if they say Andrew and Grace agreed to a deal for pens, but if the pen explodes on Grace, Andrew's not liable for any damages. That's material. If I add that clause, that'll be knocked out. So we have the no consideration modification, the Battle of Forms, knockout rule, firm offer rule. Written confirmatory memo comes up a lot. After an oral agreement, a party can send a written confirmation that includes the quantity and description of the goods satisfying the statute of frauds, and the receiving party has 10 days to reject if not, the offer will be accepted. So this is when Andrew and Grace have that offer to buy 10 pens, but the pens are $100 each, so it's $1,000. Statute of frauds. Written confirmatory memo rule is an exception to the statute of frauds. If I send her an email after and say, hey, Grace, this is to confirm our agreement for 10 pens at $100, signed Andrew, we do have an agreement. I'll get into exceptions to the statute of frauds, and that written confirmatory memo comes from that, mnemonic swap written confirmatory memo. So let's rewind a little bit. Take a sip of water.
Andrew,
Yes, that's me.
let me ask you something, because see, I had it that the Battle of the Forms had to do with the language that was written in behind the purchase orders, in these orders that are exchanged amongst merchants, and that one might have language in the back that doesn't, address, it's not addressed. The seller has language and the buyer has language, but they are exchanging these orders which are not signed. Then the last shot rule tells them that the last document that was sent before it was performed would be the one that came into play before the court does the knockout rule that uses the gap fillers. Is that still right, or?
Exactly. I mean, what I was explaining was more conceptually. What you were explaining is more concrete. That's exactly what it means. It's the forms where between merchants, every merchant has a standard form that they fill out. So when they send one form and then the other party accepts by sending their form, and their form includes additional language that is immaterial, it will be included so long as it does not materially alter the contract. When their form includes, material
arbitration and all that stuff that includes in the back, the little language that's written back there and all that stuff. Okay, so that's true as well.
Exactly.
Okay.
And on the MBE, they'll ask it more in that way of having forms. On the Florida essays, they ask things so abstractly that you can just talk about this. Like, are they merchants? And if they are, then this will be the way that the acceptance and the offer will the requirements of such. Remember what I said 2 days ago or yesterday, or if you didn't hear it, I'll say it again. At common law, we have the mirror image rule, right? Which means that the terms of the offer and the terms of the acceptance must match exactly. Under the UCC, we have this Battle of the Forms provision where an additional term that does not materially alter the contract will be included. So we're more strict about the offer and acceptance at common law. Under the UCC, between merchants, where there's a little bit of leeway for, okay, additional term, yeah, we might include it. If that happened at common law, let's say, let's say we had an agreement to do tutoring services, right? It's a service. And I said, I'll tutor you for, 10 hours for whatever, some number, let's say $1,000 an hour. And then you reply, yes, but I need the tutoring on Tuesdays, right? Under the UCC, that might be a contract. That might be, the day of the week might be material. Under the common law, absolutely not, because your acceptance did not mirror my offer. My offer said, tutor you for 10 hours at this rate. You said, yes, I'll get tutored that many hours at that rate, but I want to decide the day. That is not going to be an acceptance under the common law. So let's keep that in mind. Mirror image under common law, Battle of the Forms provision under the UCC between merchants. But once we get to the execution of the contract, it actually flips in where there's more leeway. There's more leeway under the common law because it's substantial performance. You just have to do a pretty good job and do your best to finish painting the house. Maybe there's some damages, but it's not going to be like they didn't get the benefit of the bargain. Under the UCC, merchants, we have the perfect tender rule, where it has to be a perfect tender. So if you don't deliver 500 red widgets as stated in the contract, then that constitutes a non-conforming shipment or a non-conforming delivery, and that's a breach. So let's be pretty clear on that. Okay, so when we're writing the essay, we don't want to get lost in the sauce. That's one of my favorite phrases. But we do want to get our points about whether there's a contract, what type of contract is it, what is the governing body of law, and it's important to note that they're merchants. Why? Because there's special rules that apply to merchants, and we may consider them. And then we're finally going to get into contract formation. most people just jump into the issue is whether there's a contract requires offers, acceptance, consideration, no valid offenses. Now, are there some model answers that do that and they're picked as the model answers? Yes. So like, do you even get any points for any of the stuff that I'm doing right here? Definitely for the UCC versus common law thing, you get points for. You know, identifying whether there's a contract, what type of contract is it, and that they're merchants, you do get points there, but it's not like guaranteed that every essay there's an opportunity for you to get those points. But in my opinion, it's nice to do a clean sweep and give the reader the chance to give you points if there are points to be given. But again, don't spend too much time on it and try to focus on answering the question directly. Oaks, issue, rule, analysis, opposing argument, conclusion. The issue is whether there's a contract. It seems like there's a contract. The issue is what's the governing body of law. We're going to say UCC. However, there may be an argument for predominant purpose test. However, the court on balance would likely find UCC. It's important to note that they're merchants because these are special rules that apply to merchants, and we may consider them in our analysis of the contract. Like, I just breezed through that, got some points, and kept it moving. Keeping it moving is a key to this. Practicing is a key to this, because one thing that happened to what's his name, ECE, and before the recording started, I showed everyone. Maybe I can show something real quick. No, I don't have it anymore. But I showed everyone the rap album and the names and the artists, whatever, and the name of the artist and the name of their album. And ECE, he's famous because he failed by 1 point the first time he took it. He passed MBE and failed Florida by 1 point. And he was super determined on the retake and crushed it. And one of the reasons why I crushed it is because the first time he took it, and I warned him about this, he ran out of time because he was just writing so much. But in the quest to write everything you sometimes don't have the opportunity to write very important things because you run out of time. You have to find that balance. So the second time, ECE, I'm going to call everybody by the rap name for now, he practiced. He was practicing writing 2 essays a week. And so he really found his groove and found his rhythm and found out, okay, this is how I write everything I want to write, because that was his thing. And even like during class when I'd, call on someone to talk, he would love to elaborate. Some people are very elaborative, and that's good, but you have to strike that balance with elaboration and moving forward. I think I'm doing a pretty good job with my mental clock right now. And when I want to end class with, okay, I've gone through these 3 subjects. I think I've done them, completely but concisely, right? There's a balance between completeness and conciseness, and we always want to try and strike that. Okay, now we get into the big piece, which is contract formation. Oh, someone said they've been in the waiting room for a long time. Okay, someone was supposed to tell me if there were people in the waiting room. Oh, 2 people. And any chats?
I didn't see anything.
Thank you, everyone. It's not hard. It's a silent killer. Oh, sorry. I don't mean to show anyone's private messages to me. But the albums are doing whatever. The sooner the better. Yeah. No. Hey, am I on echo right now? Okay, no. Welcome to the students who just joined. I'm sorry if you were in the waiting room and I didn't notice you. Sometimes I get carried away with my teachings. But one of the students who just joined us is actually the creator of this outline. We had a session together, and she did an amazing job. So thank you, Shelby. And as we continue, I just want to recap for her and Jackson, who just stepped in the room, or you might have stepped out, step back in. We just talked about whether there's a contract, the governing law, UCC versus common law, predominant purpose test, and noting if they're merchants or not, because there's special rules that apply to merchants. We go through those points quickly and efficiently, and then we get to the thing that everyone loves, which is contract formation. The next issue is whether there's valid contract formation between the parties. Contract formation requires offer, acceptance, and consideration. Gabby, are you here? Is it your birthday today? Yeah, it's your birthday, right?
Yeah.
Okay. No, I'm just trying to talk this one. Okay, so what is an offer? Offer is an outward manifestation of intent to enter into a contract with specific terms and communicate to the offeree. Acceptance is a manifestation of intent to be bound by an offer. It can be expressed or applied. There must be mutual assent and meeting of the minds. Love that. A lot of people have different definitions, but I'm just key on key terms, and I like mutual assent, meeting of the minds, intent to be bound by. These are good phrases for offer and acceptance. consideration in Florida, consideration is a bargain for exchange of legal value or detriment. Is there sufficient consideration, or is it moral or past consideration? These are just some points that I pointed out. Like, look into the consideration. Is it a debt that was already paid or already, obligated to be paid, and now they're trying to use that as consideration today? Or was it something that they already were legally obligated to do, and now they're trying to use it for consideration now? I think it's rare on Florida essays that lack of consideration is a valid defense, but it's just something to think of. So, I know I've spent much more time on the first three pieces than the big one that you have to talk about. But does anyone have any real questions to offer, acceptance, consideration? And before I ask questions, one point is, remember mirror image rule. The offer needs to match the acceptance exactly if we're under the common law, and the firm offer rule potentially, but the battle of the forms provision, where under the UCC, an additional term that is not material will be included in the contract, and there will be an acceptance. So this is where you talk about that in contract formation. These things that apply to merchants above, you'll talk about later, right? But you just kind of want to think about them or note them above. Okay. Offer, acceptance, consideration. Any questions about these things? Mirror image rule, battle of the forms provision. You got to write about offer, acceptance, consideration. Like, if you're not mentioning them on your Florida essay, you might as well just take the essay again in July, because these are the key points of a Florida essay: offer, acceptance, consideration. Now, this part is the easiest to remember the rules, but actually I think is the hardest to do the analysis. Why? Because a lot of times in these essays, it's convoluted. There'll be, on July 6th, Tommy offered to buy the Cadillac, but on July 7th, Tommy, offered to buy the Honda and told Johnny he was no longer buying the Cadillac. On July 8th, crossed in the mail, ooh, that's a good thing. Mailbox rule, that could come up right here. The mailbox rule can certainly come up right here. Does anyone feel confident of explaining the mailbox rule to the class?
I can, if that's all right.
That's what I want to hear. Let's do it.
So the mailbox rule essentially is acceptance is valid when it's sent, and if the person sends an acceptance and then a rejection, whichever arrives first is the good one.
Exactly. And what he means by the first piece is that if someone sends an offer and then it hasn't been received yet, it's not effective yet, because there's no way that the offeree has any notice of the offer. But once they receive it, okay, now we have an effective offer. Now, what about the acceptance? Well, the acceptance, once they've sent the acceptance, regardless of whether the offerer has received it or not, there has been a meeting of the minds, right? Because the person sent an offer, they knew what they were doing, and then the other person received it and accepted it and put the acceptance in the mail. So he's right. The mailbox rule really means that acceptances are effective upon dispatch, where mostly everything else is effective upon receipt. But then he's right about rejections too. That is whichever comes first, because we have a special scenario there. Any questions about that? So just when you're writing about offer, acceptance, consideration, think about that. Think about the chronology of the events that occur. And I think it's always best to do it in chronological order. Be like, July 6th, when Tommy expressed, and then just quote it, this to Johnny, this likely constituted an offer because XYZ. Or when on July 3rd, when Johnny expressed this, quote it, to Tommy, this likely was an invitation to deal, or this was just an advertisement. That's another thing, when does an advertisement constitute an offer? These are things we can think of right here, but don't forget to do the analysis. When I read essays, I find that your analyses are lacking. And I'm not trying to single people out right there. That's just a general, people do a good job spotting the issues and writing the rules, but their analysis is like, come on, are you guys lawyers, or are you just people who memorize rules? The analysis is where you show your, you flex your legal muscle. Tommy's going to argue this. Oh, I got some real creative thing in the chamber, that I'm going to shoot out to the audience. But Johnny's going to argue this. On balance, the court will find that. I really want you guys to dig deeper in the analyses and use the facts. Don't just recite the facts. That's a terrible idea. But you can interpolate the facts, like if you see a fact that's important, it's okay to paraphrase it or quote it briefly and then explain why that's important. Any questions about contract formation? Anything at all? I don't know what's good, but I'm pretty good at muting and coughing. I've mastered that trick tonight. I feel fine. I guess I was in the gym today or something. Okay, so defenses. Defenses is huge. Anyone besides Gabby or Grace wants to be my partner in crime today for defenses? Anyone at all? Just say hi. All right, Gabby or Grace, you want to say hi?
Hi.
Hey, you're the best, Gabby. All right. So
I think everyone is feeling how I felt when I first saw this, and they're all kind of nervous.
Yeah, no, I know. Nervous, shy, camera shy, whatever it may be. I'm fortunate to have you here on your birthday, partying with me and the team. All right, so let's continue with defenses. So defenses are huge. We've talked about whether there's a contract, who are the parties, what type of contract is it. We've talked about contract formation. Now we need to talk about defenses. And I've literally never seen a Florida contract essay that doesn't allow you to bring up the defense of the statute of frauds, right? Under the statute of frauds, there are certain contracts that need to be in writing and signed by the party to be charged. Everyone knows that, right? Those contracts include marriage, contracts that cannot be completed within a year, contracts for land, executorships, goods over $500, guarantorships of health insurance agreements in Florida, and sale or suretyships or sale of goods over $500. So marriage, contracts for land, executorships, goods over $500, and suretyships. So, yeah, we have a question for you. If I agree to tutor you for the rest of my life, does that contract need to be in writing under the statute of frauds? It's not a trick question. It's not a trick question. I asked you yesterday.
Yeah, it has to be in writing because, or no. No, it doesn't. I'm being tricked again. It doesn't because you can die like the next day.
Exactly. And the reason that one's hard for you to conceptualize is because, like everyone knows, I'm going to live forever. I used to tell people that when I was a kid that I was going to live. I swear that my goal is to, I used to say to my teachers, I was born in 89, and they'd be like, what do you want to be in life? And I'd be like, I just want to live to see 3 centuries. And they'd be like, what? And I'd be like, yeah, I did the math. I just have to live to be 111, and then I'll see 3 centuries. And they'd be like, you're super weird. And I'm like, yeah, I know. But I always have planned on living long. So you and me both think I'm going to live long and believe I'm going to live long. But the rule is contracts that cannot be completed within 1 year. Impossible. It is very possible that something happens to me within a year and the contract is completed. Another common example of that is, old people homes or retirement homes. I didn't mean to say that, offend anyone. Retirement homes or geriatric. I think that would be even more offensive. But retirement homes. Let's say, someone agrees to take care of grandpa for the rest of his life and he's 88, and then the day after they start doing the care, he dies, and there's no writing. It didn't need to be in writing because it could be completed within 1 year. So contracts for marriage, that's prenups, and in Florida, postnups by statute need to be in writing. Contracts for land always need to be in writing. Executorships. So when you think of an executorship, think of like someone who's going to be in charge of your estate. after you die, or someone who's going to be in charge of your personal affairs if you become incapacitated. Sale of goods over $500, pretty clear. And then suretyships or guarantorships. That's just a promise to pay the debt of another. So they all need to be in writing. So we can say under the statute of frauds, there are certain contracts that must be in writing and signed by the party in charge. Those contracts include contract for marriage, contract for land, executorships, goods over $500, guarantees of health insurance health insurance guarantees, and sale of goods over $500. Here, since there is a sale of goods for $800, Jay will argue that the contract needs to be in writing, right? However, there are numerous ways to overcome a statute of frauds defense. So I just zoom through these when I'm writing. I like to write the entire mnemonic, not the mnemonic, but my legs, all the elements of my legs, and I like to write all the elements of swap. Especially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. Why do I like to write all them out? Because I believe in the way of writing is to give the reader an umbrella statement of the rules and then narrow it down to the most applicable rule and then do the analysis. Give them a little bit of background framework and then lead them to where you are precisely applying the rule. So I'm going to be like, this statute of frauds seems applicable here. These are statute of frauds contracts. However, there's exceptions to statute of frauds. These are statute of frauds exceptions. Now let's do the analysis. Here we have goods over $500. It should be in writing. However, it's specially manufactured because it said Ibis Prep and had my little name and signature on it. So therefore, the court will likely find that under the specially manufactured goods exceptions to the statute of frauds defense, Johnny will prevail, and it did not need to be in writing. Something like that, but allows you to really touch the points and maybe get points. Touch, the issues and maybe get points. So especially manufactured goods, we know what that means. Written confirmatory memo, remember that applies to merchants under the UCC. That's like we say something on the phone, and then you later have the email that confirms if it's under the UCC, the essential terms. And this is something I should have mentioned. Essential terms under UCC are going to be quantity, description of the goods, right? It doesn't need to be price, but it does need to be the quantity and description of the goods. So that needs to be included in the confirmatory memo. Admission in court, it's pretty obvious. Promissory estoppel, that means it would be unjust not to enforce the obligations of the contract. So yes, it wasn't in writing, but one party detrimentally relied on the contract, and it would be unfair not to enforce it. Maybe you got unjustly enriched, or they received ill-gotten gains. And then partial performance, right? You've already started. Like a unilateral contract. Once you've started performing, then it's irrevocable. Or land, if it's they've made improvements, they've made payments, or they've occupied the land. Two of those three things, then we'll have partial performance for land. So, key concepts and good things to get points on. The first major defense to a contract is going to be statute of frauds. We want to remember that my legs mnemonic, what contract statute of frauds applies to. And we also want to remember the swap mnemonic when there's exceptions, when there's ways to overcome the statute of fraud exception, especially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. Any questions about statute of frauds? Make sure you understand how to write that analysis well. Okay, other defenses formation, you could just list them out. Other defenses remember, be careful. You're not going to get a point for just listing all the defenses, but it does kind of help you if you mentally or physically list them all out and then apply the ones that are most applicable, because it's kind of my way of writing. Like, show the reader all the defenses. It's kind of like, imagine you're working at an ice cream shop. The kid comes in and you want to make the sale. You want to do, get your commission. So you'll say, hey, buddy, look, we got chocolate, we got vanilla, we got strawberry, we got moose tracks, we got upside down cake, whatever you like. You want some sample this, sample that. Okay. Oh, you like chocolate, you like chocolate chips. Oh, you like mint? Oh, we got this mint chocolate chip for you. Boom. You know, let me tell you all about this mint chocolate chip. It was raised in whatever. That's my point. I told him about, you know, the vanilla and the moose tracks, and I told him about the overview of flavors. But once I got an idea of what was his flavor palette, I really narrowed it down and focused on it. That's what we're doing here with these essays. Same with the defenses. We could potentially tell the reader these are all the defenses, and then these are the ones that apply, and the ones that apply give, you know, more complete definitions and do more sophisticated IRACs, issue rule analysis conclusion, issue rule analysis opposing argument conclusion. So we have fraud, duress, incapacity, which is intoxication, infancy, mental impairment, unconscionability, procedural and substantive. Procedural unconscionability is like unfair bargaining power. You know, there was one party who was just like in an unfair position of power, and then substantive is like oppressive terms. You know, I agree to tutor you for $1 million an hour. Undue influence is like because of the scenario, the situation, or because of a confidential relationship between the parties, there was a reason why a contract was made that probably shouldn't have been made. Like if, you know, I'm like, hey, you know, daddy, you know, you're not doing well and Brian never comes to visit you and I'm not going to visit you anymore, then unless you put me in your will, that would probably be undue influence. It's very gray whether that would also be duress, because duress is a threat, but there's no physical threat there. So that's why we think it's undue influence. And that's why that's an MB question. That is undue influence. I digress. But duress involves a threat, right? Misrepresentation. So that's when you, like, you know, mislead someone, similar to fraud. Illegality is the subject matter, like drugs or, you know, some illegal things. Illusory is like an empty promise. I promise to tutor you when I feel like it. Now, if I say, okay, Andrew, you tutor me and I'll pay you when I have the money, that's not illusory, because the courts are going to try and enforce promises. It would impose a burden on me to prove that you had the money, and then you have to pay me. Mistake, this one comes up a lot. I'd say if statute of fraud comes up the most, mistake comes up the second most. There's mutual mistake and unilateral mistake. Mutual mistake is when, you know, I thought this, you thought that, we were totally wrong. There was no meeting of the minds. We should either reform the contract to make it what we would like to agree upon, or totally rescind it. Unilateral is when one party's mistaken. And usually when one party's mistaken, they're going to have to bear the burden of that mistake, unless the other party knew of that party's mistake and essentially took advantage of that, right? Then we'll have some bad faith. Remember, good faith will always prevail in contract claims. So make sure you know the difference between unilateral mistake and mutual mistake. Mutual mistake is when both parties are mistaken and there's a reformation or rescission is proper. Whereas unilateral mistake is when one party's mistaken, and if it's reasonable that they were mistaken, the other party had no way to know, then they're going to have to bear that burden. But if the other party knew of their mistake and essentially took advantage of them, then we are going to say that the other party could potentially void the contract or seek damages. So I had my students separate this into defenses to formation and defenses to execution. I don't think that's very important. I just, you know, like to really get down to the details. So defenses to enforcement could be impossibility, impracticality, and frustration of purpose. Impossibility means it's totally impossible. There's no way for me to do it, right? Like, let's say tutoring. Let's just say another crazy pandemic. Oh, I'll throw some people back. I guarantee some people here are actually, no, you are a little bit older. I teach younger people and I have younger people on my staff. Everyone here is by definition a little bit older. But remember the Y2K bug? Some of y'all are probably really young when that came about. But let's just say there's a new Y2K bug and it's going to wipe out all electricity and all internet. And I am on a boat in the middle of the Atlantic Ocean. And I want to do class tonight. I would be able to argue defensive impossibility. It's impossible. There's no way on earth that I can get to a place and teach people live. All the internet and electricity has been destroyed. Like, even then you could maybe argue some like, oh, it's impractical, it's not impossible. Maybe you could call Elon and get a rocket ship, but like I'm trying to give you all an example of like it needs to be so impossible. There's no way to enforce the contract. Impracticability means it would be really difficult to do, like a rise in price, an unforeseeable rise in the supply cost, or flooding at a wedding venue. I'll talk about the wedding venue a lot because weddings always are contract claims. So the wedding gets flooded. It's not impossible. We can still do it there. It's just impracticable. It would not be a good idea to do it there. It'd be hard. Or let's just say like they closed down one road and now we're having an event. So traffic's going to be crazy. It would still be possible to do it. It would just be impracticable because you'd have to have everyone sitting in traffic. Like last year's Christmas party, we did it during Art Basel here in Miami that weekend. Very impracticable. This year we moved it up a week early. So impractical could be like it's difficult to do. Impossible means there's no way to do it. Frustration of purpose means it's not impractical or impossible. We can still easily do it. It's just the purpose of doing it has been frustrated. A great example I came up with today is the wedding. Tommy and Johnny are going to get married, but then, as lovers do, they fight right before, a month before the wedding, and they don't want to get married anymore. So now the venue is like, yo, you guys have this place rented out. Tommy's going to make the purpose of renting out this venue has been frustrated. We are no longer in love. We're no longer getting married. It's very practical to do it. It's very possible to do it, but the purpose has been frustrated. Those are some defenses: fraud, duress, incapacity, incompatibility, undue influence, misrepresentation, illegality, illusory, mistake, impossibility, impracticality, frustration of purpose. So we've gone through this essay pretty smoothly. Is there a contract? Who are the parties? What's the governing law, UCC or common law? Are they merchants and why is that important? Contract formation, offer acceptance and consideration, consider mirror image rule, mailbox rule, go through chronological discussion, firm offer rule, options contract, the contract will stay open, firm offer between merchants will stay open it's irrevocable for up to 90 days, things like that you talk about at the beginning. Then you go into so you kind of arrive at, therefore, absent any defenses, there's likely a contract between the parties. When in doubt, assume that there's likely a contract between the parties because they're not just going to have you stop writing the essay. They want you to get to defenses. They want you to get to damages. So once we got into, it seems like we have contract formation, we want to go into defenses. Go through the statute of frauds, go through statute of frauds exceptions, go through defenses to formation, go through defenses to execution. Try to get as many points as you can. Don't overlook breach. Usually, in my opinion, both parties breach. A doesn't pay and B doesn't perform. So A argues that B breached the contract, B argues that A breached the contract. Here's also a great part to bring in anticipatory repudiation, because that goes right along with breach, right? Like an anticipatory repudiation is when you unequivocally demonstrate intent not to honor the obligations of the contract. You could sue then for breach, or you could wait until the breach occurs and sue. But just kind of have that in your mind. So the next issue is whether there's been a breach of contract. Breach can be material or immaterial. A material breach is when a non-breaching party does not receive the benefit of the bargain. And an immaterial breach is a minor breach that does not give rise to rescission. So good phrases, you just want to do an analysis. Issue, rule, argument, opposing argument, conclusion. The issue is whether there's been a breach. The rule is what material and immaterial breaches are, or what an anticipatory repudiation is. The analysis is whether there's, a breach by not paying. The opposing argument is you didn't have a duty to pay because XYZ. All these things come into effect during breach. Any questions so far about anything before we get into damages?
Go ahead.
Good questions. I like that. Go ahead,
Okay,
Grace.
so I was wondering if we should add parole evidence.
Yes. So parole evidence is included at the bottom of this outline, just like anticipatory repudiation is. Parole evidence is good to bring in over defenses. It's good to bring in formation. When I get to the bottom of this, other issues, anticipatory repudiation, parole evidence, non-competes, liquidated damages, according to satisfaction, those things I say interpolate throughout the essay. Meaning like, yeah, parole evidence probably would have been brought up by now. I just haven't covered it in this lecture, but yes, in your essay, it probably should have been interpolated by now before damages for sure. Great question, Grace. Someone else had a question?
Yeah, I had one. So, writing a contracts essay, like going over, special rules for merchants or defenses, this is somewhere where I think I get lost in the weeds, both in practice and then like on the bar last February. If certain like special rules for merchants or certain defenses aren't like, if you didn't actually spot them in the essay, is it worth mentioning them in list form if you're not going to analyze them? Because I've spent time like during essays like thinking about am I just showing a grader like, hey, I know some stuff, like here's a list, or are they looking at it like, no, I just want you to talk about these defenses because they come up in the essay, or only want you to talk about these special rules for merchants, if that makes sense.
Makes total sense. Again, it's all about striking a balance, and it's all about practicing to kind of get that group, because it sounds like you had a similar situation to Joel or ECE had, where you're overwriting. Me, I guess everyone can kind of observe this about me by now. I'm very fast. Even when I play sports or when I read books or anything I do, I'm just quick thinker, quick mover. Like that's helps me be great at this thing in life. Trust me, it has its detriments in other places in life. But being able to move fast is great. And if that's not your top skill, you do have to kind of work on that and moving at a brisk pace. A lot of people have accommodations for this test, and that really, really helps. If you do or if you don't, no matter what, you have to work within your pace. Now, why I say that is because given all the time in the world, I do think it's good to quote unquote list all of them, because it does show the reader what to pick from. But at the same time, it's not good practice to just write lists and like be not writing good analysis. The readers want to see you the readers want to see you analyze the issues. They don't want to see you drop rules that are inapplicable. But if you can write it in the style that I'm teaching, where you tell the reader what the rules are and then you narrow it down, that's the happy medium. One solution I have for contracts, I believe, is writing damages first. I really think that's a strong choice for essay writers for contracts. Just go to the bottom of your paper, wherever, you can write at the top, and then just move up and start writing it, press enter, 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 and then just write above it, and just write this exact thing. For breach of contract claims, there are two types of damages available: legal relief and equitable relief. Legal relief includes compensatory and punitive damages, although punitive damages are rare in contract law. The main form of compensatory relief is expectation damages, which put the non-breaching party in the position they would be if the contract had been performed. There are consequential damages, which must be foreseeable, and incidental damages, which are recoverable, and the incidental damages which are incurred as a result of mitigating the breach, right? And then I might just put in parentheses, like to talk about later, like reliance, restitution, cover, nominal loss, wages, lost profits. Just like put them in parentheses, like maybe I'll touch them later, maybe I won't. Then I would say there's also equitable relief, which includes specific performance for art and land, injunctive relief, reformation, rescission, and quasi-contracts, right? Like, just say that little phrase right there, and then you could go into your analysis at the end. But it's like, I want people to get really good at that type of phrase. Like, here is my overall statement that does include a list, but does it in a really quick way, defines things that are important properly and things that are unimportant quickly. Like, I'm a big fan of being like, the UCC includes contracts for goods, and then next to goods, just in parentheses, saying all things movable. You don't have to write everything in such structure. Like, The UCC includes contracts for goods. Goods are defined as all things movable. You know, like, I don't like that choppy way of writing. I like that smooth way of writing where you kind of get points for reaching for them, but you stay focused. So my answer to that question is, like every law school professor, they either say it depends or it's a balance. And this one I'm going with, it's a balance. You want to focus on the issues at hand and the issues that you know you're supposed to write about, but you do want to mention, you know, the other, you know, ice cream flavors available, just so that they know that you're not just like, you know, too tunnel vision. I'm telling you, I've taken MBE, I've taken California. Those are more tunnel vision essays. These essays, they want you to elaborate, but not at your own detriment. And you have to figure that out on your own. That's why I say 20 times essays. Because by the time you're writing 21, 22, and 23, you're going to know your pace. I am a man of learning and making mistakes and learning the hard way. I took the MEE last July, and I took the MEE and the MBE. And, you know, I was like, cool with it. I did well. The MPT, which is the model performance test, I kind of like listened to my instructor, Matt, teach the class. And then I studied a little bit here and there, but I overlooked it. I didn't write as many practice essays. It was a 3-hour essay, 2 essays. I spent 2 hours on the first one and 1 hour on the second one. I ended up doing really, really well because, like, you know, I studied, I do this for a living, but I was freaking out when my tests coming out because the second essay, I have never in my life had to do something more uncomfortably fast. Like, I was reading the case pattern and just, you know, like writing like a monster. I did much better on the first essay, obviously, that I spent 2 hours on, than the second one. Why? Because the first essay, my OCD kicked in. I was so concerned with formatting and making sure that to, from, read, date, and making it look beautiful that I went over my time. If I did the UBE again, I would write 1.5, 1.5. Like, when you write your essays, it should be 1 hour, 1 hour, 1 hour. So I really want everyone to not make the mistake I did, which is absolutely not writing enough practice essays, and write these practice essays so that you can find that balance. So long answer to a short question is you should strike a balance between demonstrating to the reader that you know the subject matter and not just writing lists, because they do hate that. They don't want you to outline dump, but there's a way of smoothly writing, including these are the types of relief, blah, 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 coming back to it later and then saying, here, Jay will argue for expectation damages. He will blah, blah, blah. Alternatively, Jay will argue for a specific performance because of this. You know, so good question. I'm going to keep it moving, though. So damages. The last issue is whether either party is entitled to damages. Damages can be legal or equitable. Legal relief can be compensatory or punitive. Punitive is rare in contract law. Compensatory relief, expectation, puts the non-breaching party in the position they would have been if the contract had been performed. Consequential, damages are foreseeable in the event of a breach. Incidental, losses incurred as a result of mitigating the breach. Reliance, so under a theory of promissory estoppel, a party can recover for damages incurred as a result of reasonably relying on the execution of the contract. Restitution, this is my rap album, to disgorge ill-gotten gains. Ill-gotten gains are my rapper name. Like a deposit, if you put a down payment and they're going to get that paid back. Cover damages or damages incurred for finding a replacement at market value. You know, the cost of cover. You were supposed to send me the peaches, you didn't. I had to buy peaches somewhere else. This is the cost of cover. Nominal damages, name only, lost wages, lost profits. Don't get in the weeds. If all you talk about is expectation, consequential, incidental, and all you mention is expectations, put them in the position they would have been, it makes them whole. Consequential, foreseeable, and incidental are losses incurred for recovering for the breach. You did a great job. Restitution and reliance are some big ones that could come up and you could get points for. Equitable relief is court enforced. So specific performance, forcing a party to perform, which is appropriate in land or unique art, never appropriate in services because that would amount to indentured servitude. If I don't tutor, you can't force me to tutor. I'm not a trained monkey, I'm a real human. Injunction, forcing to act or not to act, like a restraining order. Reformation, look for reformation. If there's a mutual mistake, reformation is a great remedy to modify or edit the contract. Rescission, revoking the contract, tearing it up. There was no meeting of the minds. rescission is also a potential remedy for a mutual mistake. And then a quasi contract is a court ordered contract, like you know, they order the restitution contract, or they create a promissory estoppel based contract where it'd be unfair for them not to have a contract. So it's also known as a fictitious contract, as a quasi contract. Any questions about damages? And I know I'm kind of rushing through damages, and that's kind of like a good similarity between what's going to happen to you all. You're going to rush at the end, and you're going to rush through damages, but just it's the same every time. Mention the types of damages. It's mainly expectation versus specific performance. Think about restitution, reliance, reformation, rescission, the big R's, and try to apply them. Just because I know the birthday girl has a reservation and is leaving in 2 minutes, I'm going to move forward and finish this essay. But then after I stop the recording, I'll stick around and people could ask me questions. And on Saturday, we're going to do a 2-hour workshop where I go over live essays. And this stuff is going to get really repetitive. The main thing is do the questionnaire. The Florida questionnaire, it's already filled out. We have it filled out, but I want you to fill it out on your own and memorize it cold. Because if you can memorize it cold, you're going to pass these essays. I promise you that. All right. So Gabby, just hang in there. I'm almost finished. So other issues that you should interpolate throughout the essay. Anticipatory repudiation, when one party clearly and unequivocally demonstrates an intent to not carry out the terms of the contract. I talked about this earlier. It has to be clear and unequivocal. It can't be, I'm thinking about not doing the contract, or, you know, I'm not going to do it unless I'm legally obligated. That's not going to count as anticipatory repudiation. Parole evidence, as Grace said, look for parole evidence. Oral evidence that contradicts the terms of a fully integrated contract is inadmissible unless it's a clarified and ambiguous term, to show a condition of contract, to show a defect in formation like fraud, duress, etc., or show trade usage. So here you're looking for, you know, we have a written fully integrated contract, but now we want to give evidence of the conversation they had on the phone. Well, it's usually inadmissible unless it's showing a nuance. If it's nuancing the conditions of the contract, that's okay. If it's totally replacing them and modifying them in a way that's totally different, then that's not okay. It's not allowed to contradict. It's allowed to add sort of clarify an ambiguous term, to show condition, show defect information, or show trade usage. That's going to be parole evidence. So definitely look out for parole evidence. There's no E at the end of parole. We're not on parole here. We're just talking about parole evidence. So anticipatory repudiation comes up, parole evidence comes up, and then non-compete agreements come up a lot. They need to be reasonable in duration, which is the length, the subject matter, what we're talking about, and the geographic scope, how far. We can think of 6 months as presumed reasonable, over 3 years presumed unreasonable. You know, it's based on the industry. So if it's tutoring for Florida bar, it's going to be based in Florida, not national or global. Patents, non-competes are 5 years in Florida. Sorry if my voice is sounding annoying right now. Trust me, it's more annoying for me to talk. And then liquidated damages. So liquidated damages are damages that are contemplated ahead of time when they'd be too difficult to measure because they'd be too speculative in the amount, in the event of a breach. Think of construction contracts. We have someone doing the lighting, someone doing the roofing, someone doing the flooring. Well, we can't do the, flooring until the lighting's in. So the delay liquidation clause in the contract would be for any day of delay, $500 for the lighting guy. Now, liquidation damages have to be reasonable. They usually should not exceed 20% of the contract price in Florida, and they cannot be a penalty. So they can't be like, oh, we're going to penalize him for every day he's late, and it has nothing to do with the calculation of damages. It's supposed to be a calculation of what the damages should be. Just recognize it would be too difficult to measure that in the event of a breach. And then finally, accord and satisfaction. Accord and satisfaction is when you have a previous debt, and now you know what happens all the time. Johnny can't pay back Tommy, so Tommy's like, hey, Johnny, just pay me back half of that. That's going to be the accord and satisfaction. The accord is the agreement to pay back half of it. The satisfaction will be the payment of that amount. An accord and satisfaction will extinguish a prior debt. It has to be a written accord and then an actual satisfaction of the debt will extinguish the prior debt. So, a lot of issues to talk about. Something I really, really, really want everyone to do before class on Saturday is the questionnaire. If you can fill out that questionnaire and memorize it, you're on your way to a really, really successful experience in February. There's 2 essays assigned. I'd probably recommend waiting until after we do the workshop so you really understand how to write those essays. But you're welcome to try and write them before. But please submit them by 7 p.m. Monday. If you have to submit them later, it's fine. But the ones that are going to be graded in priority are the ones that are submitted by 7 p.m. on Monday. So in respect to the birthday girl and saying that I was going to end class efficiently on time today,